So, hold on. You know how Middleton knows everybody in St. Joe County? It was only a matter of time before we actually had one of his relatives show up. We're starting our midday with Middleton today. It's going to be interesting. And I know several of you may have already seen that particular appearance, so don't worry. There's more interesting Middleton than that to go around. We're going to follow the Middleton up with some Vann, and then after Vann, we have Judge Simpson. We'll talk about that more in a few minutes. I'll tell you why I've included this song into my rotation now. This reminds me of a group I listen to a lot called Brass Against. They're amazing. If you ever have an opportunity, check them out. Oh, what's this? It snuck up on me. I was having too much listening to that other song. What happens? Ladies and gentlemen, welcome to the Weekend Review. I'm your host, Lone Wolf Usul. I'm your curator and host for these myriad court cases that we're going to see today. And as you see in front of you, we're going to start the midday off with Middleton. Then we're going to move into some first appearances from Bay County with Judge Vann. Those are great, as always. And then we're going to follow things up at the very end with a case we've seen a lot of in the past. We followed this case on this channel on the Weekend Review, actually. This is Mr. Kelly, the gentleman who was being evicted or ejected from the trailer park. He was very disagreeable in his first appearance and got arrested because he had a warrant for driving without a license. He insisted on a trial to prove his points. He didn't show up to that trial. He lost by default, and now he's angry about it, and he's going to show up and he's going to tell us all about it. Ladies and gentlemen, I know we might have seen that video one or two other places, but We've been following that journey together. We're going to continue it together. It's just a great appearance. That's all there is to be said about it. Let's get things started, shall we? Judge Middleton from yesterday. Do I even have the video ready? I don't think I do. It's the little things. It's the little things.
Good afternoon, Ms. Washington. Can you hear me?
Yes.
This is Judge Middleton. I'm here on behalf of Judge Pattison. Also here is Casey Strong from the Public Defender Group, and she's here. You got arrested on a bench warrant in this case. That's file number 231559SM. You were charged way back in June of 2023 with kicking somebody's window out, about $700 worth of damage. And
they didn't have a
looking
receipt.
Well, just a moment, Ms.
Okay.
Washington. We'll talk about the facts. Let the judge speak about the.
But if we're talking about the facts, I didn't get charged in June then.
All
Ms.
right, well, your
Washington, don't
lawyer,
say anything right now.
Oh my God, okay.
your lawyer is Paul Gibson.
Okay, that makes
And-
sense.
Ms. Strong, you don't know this, but Ms. Washington does. She and I are related. She's about my first cousin twice removed. Her grandfather was my first cousin. And so I try not to handle her cases, but sometimes I'm compelled to. But this was a Judge Pattison case, and it's filled with Ms. Washington failing to appear when she was supposed to. There were, I think, 3 separate bench warrants. Then she failed to appear for sentencing, and Judge Pattison set the bond at $5,000 cash or surety. I'll let you, what they said is, oh no, then you were placed on probation, and there was a
16 days time
probation
served and
violation.
20 days time served.
Ms. Washington, we'll talk
Oh, yes,
about.
you got
He said
20
I'm not
days.
for stating the facts. Why can't I say the truth? And then he said I had to go to probation. He said, come check in with the probation officer until you can see if they bring me a receipt. I talked to them. They don't have a receipt. They talk to the courts. So if you want the truth, then don't Miss Washington. I'm not listening to you then. I'll stay in jail forever if I gotta
I
listen
want
to
to
you
hear
lie.
everything you have to say, but not when we're on the record. Give us a moment, okay?
All right.
We'll talk
At
about
any
it.
rate, you are correct, Ms. Washington. It was a probation violation bench warrant. And you're right, there were issues about how much the window was worth. They claimed it was worth $759. Judge Pattison ordered something less than that. He's not here today. And how did you get arrested last night?
I didn't. I got arrested this morning. I was literally walking down the street.
Okay, in Sturgis?
Yeah.
All right. Are you still at the North Centerville Road address?
Yes.
Okay, address is still correct. I'm gonna set PV arraignment for 10:30 on November 19th. Mr. Gibson is set to be there that morning. And I'll let Judge Pattison deal with this. He wasn't very happy about this, why he set the bond at $5,000 cash or surety.
You said my bond?
Yes.
How? If I got time served and the people told me that I don't have to pay anything because they don't have a receipt or evidence that I did anything.
Well, he put you on probation, and
No,
then
he
you
did not.
never complied with any of the terms of probation.
Okay, so
Well, you
I got a $5,000 bond because I'm ready to go back and lay down. I'm not in the mood for this. I've been to court like 15 times for something I didn't fucking do, and I already got 16 days time served. I'm tired of doing this. I'm tired. I just want to go to fucking sleep. Leave me alone.
All right, you got 20 days, credit 20 days, and then there's this probation issue. So you go back and
No,
take
I
a
literally
nap.
got 16 days
Judge
time served and
Pattison will
20
see
days
you.
time served. I didn't get put on probation because I don't have anything that I have to pay.
Yes, you do. I think you have a disagreement with what Judge Pattison ordered.
No,
So
I
anyway,
don't. I literally talked to people and
take
they
a
don't have
nap.
any evidence that I broke the fucking window. They said there is no receipt. I went there 3 different times and had them fax the paper and everything. And this is so irritating. Can I go back to sleep? If I got a 5,000 baht, I'm not getting out then. So can I go back to sleep?
Yes, you can.
Man, it makes no fucking sense. Every fucking open the door. Goddamn. Man. I'm embarrassing me that. This is so fucking stupid. How do I get time served and then I have to open the door?
I think you can see why Judge Pattison set the bond at $5,000. I had to study the file. She did get 20 days, credit 20 days, and he put her on a probation. And then she failed to comply with any of the terms, failed to report, failed to pay fines and costs, failed to abstain from the use of alcohol or drugs, failed to participate in treatment, failed to maintain full-time work. She had a probation violation hearing set for October 21st, and she failed to appear. See how she's doing when he sees her on Tuesday.
Yeah, I'll send Paul an email and give him a heads up.
No sense diving into contempt. Just get her on her way. Good morning,
Good morning.
or good afternoon.
Or good afternoon.
You're Leslie Ann Harris.
Yes, sir.
I'm Judge Middleton, and I met you several years ago. You and your boyfriend were charged with a retail fraud, and you were placed on a deferral, and you didn't comply with the terms of the deferral or show up for court. So the file number here is 222089. Also here with us is Casey Strong from the Public Defender Group. The allegation is way back in September of 2022, you and your boyfriend, Mr. McLean, came over to Three Rivers and stole some items from the Walmart store, stuck them in your clothing, and it wasn't a lot, $62 worth of stuff. So you were placed on a deferral, and you actually came in and I think paid the restitution. You came in April and paid $63 worth of restitution, but you didn't finish the rest of the stuff. And then you didn't show up for the sentencing in August. So I issued a bench warrant for each of you, and you got arrested yesterday?
On Tuesday night,
Where?
Berrien County.
And were you together?
Yes.
Now, you were living in Coloma. Are you still there?
Yes.
Are you still with Mr. McLean?
Yes. May I tell you why I couldn't show up to court?
Yeah,
Or
let
does
me count these days though. Tuesday was November 12th. 1, 2, Tuesday to Wednesday to Thursday. 3 more days. You have 2 days plus 3 days of jail credit. Did you get a new charge in Berrien County?
Yes, I did. I still have court on November 22nd, and I'm hoping to make it there to get that taken care of.
All right.
I don't like being in trouble. These are my 2 very first charges ever. I don't.
Well, I looked at your record again. One of the reasons why they did this deferral is you had 0 criminal
I know.
record, as far as I could tell. And it was like $62 worth of stuff that you stuck in your coat and down your pants. And so it wasn't the crime of the century, and you've paid restitution. My intention, Ms. Harris, is frankly, just give you 5. I would not have given you 5 days in jail for a $62 retail fraud. But the way this all went down, you've ended up doing 5 days in jail. So why didn't you show up?
I took the charge in Berrien for my boyfriend on accident. And got kicked out of my house temporarily and had no way of transportation, down here. And I got my community service done. I have all my papers filled out and everything still, but I didn't make it on time. I promise I'm a good kid, well, woman.
Well, I'm going to give you 5 days in jail credit, 5 days. You've paid the restitution. And I'll take you at your word, they did community service. I think you told me then that you took the rap for your boyfriend. He was handing you stuff, and then you were also picking stuff up of your own. I'm going to do 0 fine. You've already been barred from Walmart, so I guess I don't need to do that. I'm gonna do the state minimum fee of $125. Will someone bring you $125?
Today? No.
Yes. If I
No.
give you time to pay it, will you pay it?
Yes, sir.
Or make it due by December 31st?
May I also say that I have a full-time job as well? And out of Hartford, I'm a construction laborer. I have a paycheck waiting for me today. I work 7:30 to 5:30 every day.
I
Monday
can't
through
make the
Saturday.
fine any lower than
Oh, no, I just want to
125.
let you know. That's all.
All right, well, I'll trust you to pay it by the end of the year. And
Okay.
then you can pay it online. Anyway, you'll get out of jail. I'm gonna do the same thing to him. So
Okay.
will someone come over here and pick the two of you up?
Yes.
Did you get picked up in the course of being arrested, or did they arrest you on the bench on this old warrant? Did you get a new charge on Tuesday?
No, nope.
They picked
They
you up
just
on this
arrested me.
warrant?
Yep.
All right, you're gonna be released. 5 days credit, 5 days. $125 due by December 31st of 2024. All
Thank you,
right,
sir.
good luck to you.
Thank you so much.
Okay. Casey, I do have reason to believe she actually did do the community service. She just didn't show up to complete the deal. Oh, and this will not be non-public. It's no deferral. All right, you're good to go.
Thank you.
Thank you. She didn't swear at me at last as much as the last person. She was quite congenial. Good afternoon, sir. Are you Dalton James McLean?
I am, Your Honor.
I'm Judge Middleton. We met way back in 2022. I just spoke with your girlfriend, Leslie Harris. Your file number is 222088SM. You got 1 day at the front end. You got another day when the warrant was served. And your girlfriend indicates that you guys got picked up on Tuesday. And you then brought over here from Berrien County. Is that correct?
That is correct.
You were both placed on a deferral for a small amount retail fraud. And you failed to comply with the terms of the deferral. she did come in and pay the restitution in April. You were to do community service and do some other things and appear for sentencing in August. And neither one of you appeared for the sentencing. I believe it was August 1st. So what she advised is you both got arrested on Tuesday in, I'm not sure what town it was in. What town, where did you get arrested?
In Benton Harbor.
And did they just come in contact with you and found this old warrant?
Yeah.
How'd you come to get arrested?
Got pulled over.
No. What'd they do with your car?
They let us park it at Burger King. They didn't tow it.
Good for you.
Yeah.
As far as you know, is it still there?
I'm hoping so.
All right. Well, I don't feel the need to do anything more than 5 days in jail for a $67 larceny. So I'm gonna let both of you out of our jail, let you go back to Berrien County. She said she has a new charge. Do you have one also?
I do not, sir.
All right. I'm gonna do the same thing. The fine is $125, 5 days jail credit, 5 days.
So would that be today that I get out?
Yes.
Thank you so
Now,
much.
I have
Your Honor.
$300 of bond, but it's not in your name. If I could use that bond with the permission of the poster, I could pay your 125 and her 125. But you owe me $125 by December 31st. The
Okay.
bond was posted by somebody named Russell Schaefer.
Yeah.
So if Russell Schaefer will give permission, we can apply that bond to both of your fines and costs. But you don't have any deferral here. This will show as a retail fraud 3rd degree. So you're gonna get out of jail here by the next 45 minutes or so. Hopefully you can call somebody to come and get you. If Russell
Yeah.
Schaefer will grant permission to use the bond, we can pay both of your fines and costs.
Okay.
Otherwise, we'll return the bond to him.
Okay.
Hopefully you can get back to Burger King, have it your way and get your car back. You're good to go.
Thank you so much, Your Honor.
Thank you. All right, next set at this time slot is People versus Ismael Garcia. File number is 241618. Mr. Garcia is represented by Mr. Knopfsinger. They're both here.
Morning, Judge.
Good morning. This is the time and date for sentencing in the matter of People versus Ismael Garcia Jr. File number is 241618, as I said. Mr. Garcia was charged with domestic violence, second offense. We were just about to set the matter for a trial, and the defendant entered a plea. There was also an issue of a bond violation where the defendant was having contact with the complaining witness in violation of the bond. The defendant entered the plea to domestic violence first offense, and that was on October 24th. The matter was set for sentencing today. I adjourned the matter. I wanted to get victim input from the complainant, Ms. Rose, who'd been complainant in previous domestic violence charges. I wanted to talk to Dan Frazine, his previous probation officer, which I did have a chance to do. I didn't get any pictures. I did, about 1 second before I came in here, get a request for restitution regarding some medical bills. And the complaining witness is present, which I'm happy for that. Mr. Knopfinger, what would you like me to know?
Yeah, a couple things, Judge. Thank you. I want to kind of go back a little bit. This relationship has been on for about 4 years. They don't share any children together, but there are 3 children in the home. Noah, Evelyn, and Eliza. And they, the complainant is working part-time. Mr. Garcia is working full-time, so is the primary breadwinner. And what happened here, and Mr. Garcia is also a bodybuilder, and so they have this thing going. He's working full-time. He's being supported. There's a lot of meal preparation, a lot of commitment there. And from what I can tell, a really good thing going here. Then some problems arise here. Judge was paying rent, where thought that rent was paid and then it hadn't. It appeared to be a little short on money, and that's what leads to this argument. Prior to that, the landlord had been on them about missing a payment, reached out to Mr. Garcia. Hey, we need to figure this out. He felt that there was a risk of a potential eviction. So what happens that day is, talking about finances, Mr. Garcia will admit to the court that he lost his cool. And if the court reviewed the police report, Mr. Garcia sort of directed his anger towards himself. He's hitting his head against the wall. He's seeing red. He eventually, the cops are called. He's interviewed, and he says, and what he has said consistently is that he grabs her face, trying to get her to stop yelling or just to get her attention. He admits that the day of, he's arrested that morning, stays in jail until Saturday afternoon. He then enters a plea to that effect, Judge. Then after that, he's ordered out of the home. It's a no contact order. He lives with his cousin. And quite frankly, Judge, unbeknownst to me, there's money still being sent to help pay the bills because of the kids, because of the complainant working part-time. She can't make ends meet. I mean, Mr. Garcia, we talk about this. They had never done couples counseling before. My understanding, many couples fight over finances. I filed this motion, Judge, to lift the no contact, to have for this couples counseling to occur. Then it becomes known that there has been contact here. Text messages, I reviewed some of them. It seems to be that the relationship was going to, from what I saw, continue. But it was clear there was money being sent from Mr. Garcia. He took on a part-time job so that he could pay his cousin and then continue to pay all the bills there at home as well. And then it becomes known here, the last hearing, that she doesn't want to continue the relationship. And I think that was a surprise to my client. It's kind of sad, Judge, too, to see such a relationship kind of unravel. especially one that's 4 years. Mr. Garcia had been on a probation before. My understanding is he had successfully completed it. He tells me he was using some of the skills that he learned in anger management. And I will say, Judge, too, that, I don't want to excuse the conduct, but it isn't exactly it's not a drag them out kind of situation. I don't want to minimize it, right? She did go to the ER. We received the medical records and restitution requests. We're stipulating to them. Court can order that. I don't want to minimize that, what happened. We would be asking for a term of probation here, Judge, stipulating to the restitution. There is a certain amount of jail credit here. We'd ask the court to order that. And then also, court is inclined to order jail time. We ask that be ordered in such a way that it would be not interfere and put Mr. Garcia's employment at risk. Thank you.
Your Honor, if I may.
Yeah, I'm gonna give you the last word. Ms. Rose, would you come forward, please? Good morning. Are you Charlene Rose?
I am.
And you've been in a several-year relationship with Ismael Garcia?
Yes.
This is the third one of these that I've had. The first one was in 2022, and Ismael was placed on probation with Daniel Frazine, and we'll give his input in a minute. Then there was another incident of domestic violence in 2023. And you were the complaining witness in that. That is in file number 232188. And somehow they listed it as County of Saginaw, Three Rivers, Michigan. I think they had to fix the thing. And there was an allegation of an assault at your house on 2nd Avenue on August 21st of 23. The matter was dismissed by Prosecutor Marvin. He wrote, after determined in part, after discussion with complaining witness, the matter was dismissed by the prosecutor in December of 2023. And this incident took place in September of 2024 and resulted almost in a jury trial. And then the defendant entered a plea and we set the matter for sentencing. I don't know what was discussed between you and Mr. Marvin back in December of last year. But I didn't want to do this unless I got a chance to give you an opportunity to tell me what you think. So what would you like me to know? I understand you've written some comments down. Do you think you can read them or would you like the victim advocate to read them? All right, Ms. Countryman, would you come forward? All right, and this is what you wrote that you wanted me to hear? You have to say yes or no.
Yes.
Okay. This is Marissa Countryman. She's the victim advocate for the prosecuting attorney's office. Could you read that for me?
Says, Your Honor, I'm writing this statement to convey my grave concerns regarding Ismael Garcia, who has posed a considerate amount of danger to me and other women. Please consider this as an earnest plea for justice and protection. Over the 4 years we were together, our relationship was marked by reoccurring violence. Despite attending anger management and domestic violence courses, his behavior remains unchanged. We have appeared in court 3 times due to domestic incidents, but sadly, this is not the full extent of the harm he has caused. The physical assaults were so frequent, I lost count, leading to more than 2 documented hospital visits from injuries requiring physical therapy for my shoulder as a result of this most recent occurrence. Fear kept me from reporting many incidents as I feared for the safety of my children and myself. I have now realized the importance of standing up for myself, my children, and that is why I am here. The proposed plea deal, which involves only a few months in jail and work release, is not sufficient. Given his history of violence, lack of fear of consequences, reported breaches and intimidation attempt during the protective order and light sentence merely empower him. This recent jokes about his lawyer describing the situation as minimal, that he won't have to serve the full sentence, how ideal work releases for him so he can save most of his money, visit with friends, come back to meals prepared where he can focus on his physique and come out ready for a national bodybuilding competition only highlights his lack of understanding of the severity of his actions. Ismail remains a significant danger. The past measures of probation and domestic violence classes have proven ineffective. He made remarks during the of the lady trying to hook up with him, and that at the time he can follow through with her offers. I strongly urge you to impose a maximum sentence for this repeat offense and multiple counts of domestic violence, along with comprehensive probation monitoring and enforced anger management is crucial to demonstrate that such behavior cannot continue without serious repercussions. I do not hate Izzy, even with everything that has happened. I have love in my heart for him, not hate or ill will. The trauma inflicted upon me is overwhelming. Just being here, going through this again, causes uncontrollable anxiety. While I understand he wants to end the relationship, it is imperative he receives appropriate consequences and mental health services to prevent him from inflicting the same physical atrocities on his next partner. Therefore, immediate protection is imperative. My sincere hope is that he receives the necessary mental health services and realize the consequences of his actions that should be met with justice, reflective of their impact. Thank you for considering my statement, Charlene Rose.
Thank you. Now, there are 3 children. Are they all your joint children?
They are not our joint children.
All right. How many, do you have children together?
No, we do not have
All
children
right,
together.
so the way I understood it, he's working 2 full-time jobs and paying all the bills.
That is incorrect.
All right, so who's paying the house payment, the rent and all that sort of thing?
Some of it is him, some of it is me.
All right,
For the duration that we've been there, the majority of it has been me, as I work more than one part-time job.
all right, so if I put him in jail, well, right now, you're not married and you don't have any joint children. He has no financial obligation to support you. And you're sort of, yeah, you want me to give him the maximum allowable sentence, but you also want me to do some things that would be under probation, like domestic violence or mental health treatment. So if I incarcerate him, you're gonna lose whatever financial, and I guess at this point, it's probably gonna end anyway, because he's not under any obligation to pay your expenses. What he said is he was paying the rent. Well, let me add this. How much is he contributing each month to your expenses?
Right before this incident, he had started pitching in for about half of the rent, and that was it. I paid the other half, and I paid all the utilities, and the car insurance and everything for both of us was under me. I was taking care of all of that.
All right, so he wasn't keeping the family afloat. He
No.
was helping bail the boat out. But at this point, there isn't gonna be any assistance from him. You understand?
Yes, and since the last time we were here, there has been nothing, and he told the landlord that It doesn't matter that he's on the lease, he's not paying a cent of it because he's not there, and he doesn't care what happens to us if we are there or if we are not there, because it's not his responsibility.
Some of that's true. Who's the landlord?
Yesenia Sanchez.
All right, yeah, we had talked about that before. Daniel Frazine had Ismail as a probationer and said he was very respectful, very polite, but he had a concern that he was using steroids as part of his bodybuilding, which led to his anger. Do you have any insight regarding that?
I get different answers at different times. And that was one of the things before we had moved into a place together, is that was not something that I wanted around the kids in my house, anything like that. So if he was doing that, then that would have to stop, or we were not going to get into a place together. And since then I've had, sometimes I'm told yes, sometimes I'm told no, so I don't know. I believe during the incident, I don't remember if it was the one last year or the one the year before, there were some things recovered, but I don't know what the result was of those items, if it ended up being that or not.
Well, we don't test for that routinely. As I indicated, he did a good job in the first probation. He cooperated with Daniel. He did the anger management class. He paid all his fines and costs, successfully completed it. So we were both, Daniel and I, disappointed when the second case came up. And it was more of the same, where it was like grabbing your arms. You had bruises on your arms, and it wasn't so much as just manhandling you. After you and Mr. Marvin met, Mr. Marvin dismissed the case. Then 9 months later, we get this case. Then we have the fact that he was trying to contact you while he had a bond condition of no contact. What was that about?
Some of it was about finances, some of it was just different things. I did reach out to his family and ask if he was okay, because I had seen some of his social media posts and was concerned that he was going to harm himself. And obviously I love him. Been together for a long time. And I do love him very much. And it was concerned, so I reached out to have them check on him. And some of his family actually helped me with my statement, with things that they thought, because it was much shorter, but they didn't want me to leave out other stuff that they were aware of that had also happened, as it goes hand in hand with this. But I know the guy he can be. That's not the guy he is right now. And whether he's with me or with someone else, whoever he's with, he needs to be better.
Well, I won't argue with that. Probably he won't even argue with that. Daniel, he did the anger management course. Daniel proposed perhaps the entire domestic violence treatment course. It's 26 weeks. But what you're asking me to do is put him in jail for 93 days and make him lose both jobs.
He's not working at the second job. He had quit the day after our last court session.
At TSC?
Yes.
Okay. And then you also oppose work release, where he could keep his job and go to work. You don't want that either?
He works I don't remember, it's 10 to 12 hour shifts, 4 to 5 days a week. And that's where all his friends are. And he has made comments several times that it's not even gonna be a big deal, because at jail, they're gonna have his meals ready. He's gonna go
Now,
socialize with his
you
friends.
mentioned that,
put
how
money in the
did he
bank.
post this on his social media or something, or did he
No,
tell
it
you
was between a conversation with us during the no contact.
that? Oh,
That he'd be able to just put his money away, because then all he's got to worry about is court fees and nothing else. And then he'll come out ready for his next competition, because while he's in there, he's gonna have all the time to just focus on his physique.
well, we don't have much of a gym facility here in our local jail or at the probation center. The maximum allowable sentence is 93 days. The charge was a second offense reduced to a first. Second offense is punishable by up to a year in jail. First offense, up to 93 days. There's good time. 93 days, 5 days a month makes it 75 days. If he becomes a trustee, he gets additional good time, meaning we're talking about maybe 60 days in jail as the maximum. There's no guarantee he would be a trustee, but I think he would probably be fine as one. They want people that have got a discrete sentence, beginning date, end date, rather than someone's just in there for the weekend. If you went to the probation center in Three Rivers as work release, I could do the anger management as part of the domestic violence treatment as part of a probation. But I can't put him on probation if I give him the maximum sentence. There's nothing else I could do to him if he violates the probation. So it's 60 days in jail versus trying to get a handle on the root cause of the problem. All right, Mr. Garcia, I told you I'd give you the last word. You just heard what she had to say. What do you want me to know?
First of all, a lot of it breaks my heart, but I can see that she's aggravated, she's mad at a lot of things. And I was told that the relationship was over. I didn't quit my job till a week later, after a week, I think. I quit because she was roaming around the parking lot at least 2-3 times. They saw her, and I have witnesses from
At
work.
TSC?
At TSC. I don't know what she wanted, but I have texts that I screenshotted. That day after court, she texted me. Next day, she texted me. She sent me reels. She was sending me a bunch of stuff. So just 2 days ago, she sent me a bunch of reels just on a row.
What are reels?
Reels are like stories that you post, and she was slandering me on Facebook too. Stuff I didn't want to bring up, but.
So what were in these texts?
So one of them saying that, hey, I thought we said that no matter what happened at court, you were gonna still be paying rent, along those lines. Now, she wrote in a long message and just things to get me to reply. I don't know, it was to get me in trouble.
All right, let me stop you. Did you text him this last week?
This last week, no.
But when did you last text him? He said 2 days ago.
No.
All right, when did you last text him?
It was after the last court thing, because I had a message from our landlord who was trying to get a hold of him and asked me, and he is aware of the situation, and it was to get him to get a hold of the landlord. It wasn't to get a hold of me, it was to get a hold of the landlord.
Do you have those texts?
I do. I have the text. I have the messages that she'd been frequently sending me. So I decided, hey, I need to get a new phone. So that's why I disconnected my line, because it was all led to her. I mean, she could see the phone calls and everything. And God forbid there was a woman's phone in there, because she would probably call her and go berserk or say something. I was just scared.
You just told me you got text 2 days ago. She says I didn't text you 2 days ago.
No, it was from Messenger. It was from Messenger and Instagram, and I have those screenshots.
All right, did you IM him in the last couple of days?
No, I did put stuff and things in my folder in there.
So sorry, Your
All
Honor.
right, well, all right, so he isn't living there. He's prohibited by me from living there. You want him to go to jail, and he said, I'm not paying the rent anymore. And I guess if I was him, I wouldn't pay it either. And so I'm getting mixed messages here, but go ahead.
So prior to this incident, a week before, I talked to an officer. I asked, hey, what is the best way to get out of the situation? Because I'm scared for my life. I'm afraid she's going to come after me if I try to leave one of these days, start screaming or doing something. So that's going to come right back with me, because who's going to believe a big guy? Who's going to believe me, right? Guys like me don't fall into victim and to being the victim or even to play the victim card. And I'm not a victim. But the thing is that I wanted to get out of the situation the cleanest way possible. I didn't want her to come at me and then cops come to me and say, hey, why is she screaming like this? So when I talked to him, he said, get a PO. Okay, cool. I procrastinated on that. 2-3 days later, I went to the same office. Actually, I called dispatch. I called the 911 number. They came and I told them, hey, there's a heated argument. He came, the same officer actually, and he escorted me out. Now, here's the thing. I came back because of the same reason that she's doing right now, sending me those messages, guilt tripping me into coming back. Hey, we're going to be homeless. Hey, what about the kids? Hey, what about all these promises? So I came back. Actually, I came back that same night. But the thing is that I was following my steps that I had learned in anger management. Things get heated. Either you leave the situation or you do something just to get out of the situation simply. And we've had this reoccurring situation go on for a while. And I was ready to leave the relationship. Part of it is that I love her so much that it's so hard to leave the situation to begin with. Medicine that 4 years is not, attached to her, attached to the kids. But yes, I did quit my job at Tractor Supply. As a matter of fact, I was trying to transfer to the one in Goshen, but I have 3 witnesses that saw her in the parking lot 3 times. Not only that, but I'm pretty sure she roamed around my cousin, so I had to go live with my other cousin in Kalamazoo because I was staying in Centerville, but she would roam around there too. But I have proof of the messages. I have proof of the messages on Instagram where she's constantly confusing me, saying that she loved me, she hoped for forever, and I still have them. I screenshotted all of them. And she said that I'm leaving her confused because she doesn't know what's going on, that she didn't say that in court. She didn't say it was over. So what am I to do? Just left in a state of confusion. And don't get me wrong, I did want to text her. I did want to message her because again, I was getting reeled into the same situation I got reeled for the first time because she messaged me 2 days after I'd gone out of jail, or a day after I'd gone out of jail. So I'm left with, should I text her? Is she saying the truth? Did she really say that? Or did she not? Because it seemed to me that she still wants this relationship, that she still wants forever. And I have proof on message, proof of the reels that she sent me, the stories. So I'm confused.
Yeah. One thing you're not is sorry. I never heard one time say I'm sorry. It's all her fault.
No.
There's 3 separate times you've been charged with assaulting her. She says there's a bunch of other times that you weren't charged.
And I'm going to take.
And even if the other stuff where you're hitting yourself and banging your head on the wall, that's not normal. That's not behavior that makes for a good relationship. Let me ask you, are you doing steroids that make you angry?
Not at all, Your Honor. And I have told them multiple times to take tests and do what they have to do. And the only things I take high amounts of is probably caffeine and a lot of boosters, pretty much. But it's all legal, and I can show you the store where I get them at.
Tell me about the job that you do have.
The job that I do have right now, I've been in for 4 years.
which is, I forgot where that one
That's
was.
utility master.
Oh, yeah.
And I am willing to take full responsibility of this because that's not justifying my actions. I mean, I'm still fully responsible for what I do at the end of the day. Again, I'm not gonna sit here and say, hey, that's, or try to justify my own actions. And say any of it is okay, because it's still not okay to do what I did.
Andrew, you have any input on this?
Well, Your Honor, in this particular circumstance, they've been together for 4 years. 3 different incidences of domestic violence where he's been charged. I think that he talks the talk, but he really lacks insight into the consequences of his action. I think in addition to the restitution, my supposition is that probation and the 26-week domestic violence program would probably be the best outcome in this case.
For what it's worth, that was Daniel's recommendation. To get a better,
Your Honor,
yes,
can I say one more thing?
yes.
So I'm probably not gonna talk to her anymore. I did just want to say that I do love her and that I'm sorry I didn't meet what she needed from me. I know it was real. It's just, I hope that it's just bad timing. Because I had not felt, and she was very caring. She's an amazing woman. And no matter what happened between us, I mean, I don't feel like it is okay for me to have put my hands on her regardless. I feel like we should have taken couples counseling.
Couples counseling is okay if everybody's on equal footing.
Yeah,
But in a domestic violence relationship, somebody's got the power and control and the other one doesn't. So it's not a matter of couples, it's a matter of dealing with a controlling partner. And I can't tell what I'm dealing with here, but at this point, you're gonna be out of her life financially and physically. You're gonna make your way in the world without any input from Ismail is what you're asking for, including no money. And I'm sure he loves your children. They probably see him as a father figure. You've been together for 4 years and now he's gone. There's no visitation, there's no nothing. He's in jail and your kids are going, whatever happened to, I don't know what they call him. Is he dad, stepdad?
Mostly it's beefy.
Beefy. And they don't understand. And you keep muddying the waters by posting this stuff. And then you're talking to each other on the phone in clear violation of my order, which I wanted to keep everybody apart till we got this resolved.
since the last, sorry, Your Honor.
And you didn't have enough hours in the day to do 2 full-time jobs. And I don't want you to lose your job at utility master. And I'm not clairvoyant, but I don't think you are done with each other. You can't live with each other, you can't live without each other. But right now, the situation is not healthy the way it is. I'm gonna do a 12-month probation. I could always extend it. I'm gonna order 32 days credit, 2 days. And we're gonna do that on work release. The fine is 0, you got enough to pay. There's a $75 crime victims' rights fee, a $50 state minimum fee. $1,394 restitution. Charlene Rose. There's a $150 attorney fee and a $480 probation oversight fee. And you're to pay for the class. You're gonna do the whole comprehensive domestic violence class. And hopefully get a better handle on this situation. No drugs and no alcohol. And that really hasn't seemed to have been a problem. No assault for threatening behavior. No contact with Charlene Rose unless she asks for it. Let's talk about your landlord-tenant situation. You're not living in that house, and you're under no obligation to pay her rent. However, if she is evicted, you're on the lease, the landlord could come back against you for unpaid rent. As long as your name's on the lease, but you're not under obligation to pay her rent while you're not living there. She says you weren't contributing that much anyway. I don't know where the truth lies.
Well, I was working a part-time job before this whole thing happened, and a full-time job. She's only been working part-time, so.
Well, it is clear, the last 2 cases, the argument was about finances.
Yes.
So money is an issue, and the lack of money and maintaining 2 separate households isn't it. Right now, I've ordered that he not have any contact with you. Which means I don't want you to post this stuff. I don't want Snapchats, Instagrams, passenger pitching, mail. I don't want you to contact him either. But if at some point you would like to have contact with him, you can contact his probation officer and I can amend the condition of his probation. He's got to pay your medical bill, which he agreed to his credit of $1,394. I don't know if that goes to you or to the hospital. Have you paid it?
I have not yet.
All right, so it's,
I didn't know how it worked.
I'm not sure either. And I don't know whether, yeah, this will have to be paid. What's this gonna do to your ability to maintain the house on Second Avenue?
I will be able to maintain it.
All right. All right, Daniel was open to working with you again. And for what it's worth, his recommendation was similar to Mr. Rognus, that we try the whole course. So Mr. Garcia, I want you to go downstairs and check in with Daniel.
So, at some point, can I get like a day or something to just go and grab some of the stuff that I need from the house?
You're gonna need to do that through an intermediary, a brother or someone to go
Okay.
get your stuff. And then they're gonna arrange when you're gonna start your time at the probation center.
Also, I just do want to make her aware that we're both on the lease. So if I tell the landlord that I'm not gonna stay there at all anymore, it's pretty much closing both of us.
Well, not necessarily.
I don't know, that's.
Well,
this is
your
based on the
landlord
messages.
is not,
And this is why I told him that I did want to continue paying I
Well,
stopped
you can
this.
continue paying if you choose to. You're not under any legal obligation. Unless your landlord releases you from the lease, you're still on it.
I didn't want her to get evicted. I
All
didn't
right,
want
well,
her
I
to be-
respect that. She says she can do it anyway. If you choose to pay it, that's up to you, but you got a lot of other stuff. Right now, you gotta pay almost $1,400 worth of restitution. I'd use the money for that. And paying for the domestic violence class, paying your probation oversight fees. You got a lot going on here. All right, you go downstairs to probation. Daniel's watching this and he's waiting for you to come down. All right, thank you. Miss Rose, you just wait here with me for a minute.
You saw what's next, right? I don't really need to introduce it too much. Ooh, it's the cattle call from Bay County, Florida, ladies and gentlemen. Judge Vann is on the deck.
Leave it alone.
Hey, I don't see Jordani.
He's probably Raymond.
So you want us to skip and come back to it?
Oh.
Just put him to the side real quick. All right, so we'll do 21.
All right. I like. I will hold on 21. I'll stand by. Dealer, go ahead. I like to stay.
Step on the X. State your name.
Mr. Evans, fully court charges petty theft with 2 or more prior convictions. You understand that charge?
Yes.
I understand you've been given copies of paperwork and advised of your rights. Based on your application, upon you do qualify, I'm going to go ahead and appoint the public defender to represent you. Any question about that?
No.
Yeah.
Disturbing the peace out of Maryland, 23. Everything local is from 12 with a petty theft, some L&L, cruelty to a child, burglary, grand theft, L&L, grand theft. Goes back to 6.
10,000, December 2nd, 9 o'clock, no contact with Walmart.
Step to
Okay.
your right to the T. Step on the
Sure.
T. Wait.
The usual
When the
punishment.
green light comes on, sign. Next.
Is that the 8th amendment? Rolling the usual punishment.
Red X. State your name.
Or Walmart. Might qualify.
It's the pen right there. Yep.
Ms. Molnar,
State your name.
ma'am, your fully court charge is failing to appear on a littering charge. You understand that charge? It is. I see sometimes civics comes back to you when you least expect it. All right, Ms. Mulder, you've indicated you don't want a public defender, so I'm not going to appoint one for you, but you got that option later. You also have the option of hiring your own attorney or represent yourself. Judge Dyer has set your bond at $2,500. Your court date is November 18th at 1 o'clock.
Step to your right to the T. Next. State your name.
Ms. Weaver, how you doing? Can I not hear her?
She says she's okay.
I'm okay. Okay. All right. Before the court charge is off without pop. You understand that charge?
You understand what you're charged with?
I've been given copies of paperwork, advised of your rights. Based on your application, I find that you do qualify. I'm going to go ahead and appoint the public defender to represent you. So you have an attorney now. Any question about that, ma'am? Okay. Deputy criminal history.
No history.
Ms. Weaver, I'm going to release you on your own recognizance. Your court date's going to be November 18th at 1 o'clock. Good luck, ma'am.
Over to the T. Next. When the green light comes on, sign red X, state your name.
Marissa Curry.
Ms. Curry, for the court, charged with possession of meth, possession of paraphernalia, possession of less than 20 grams of marijuana, procure or offer to procure prostitution, and a violation of probation, possession of cocaine, possession of controlled substance. You understand the charges?
Yes.
I understand you've been given copies of paperwork and advised of your rights. Based on your application, I find that you do qualify. I'm going to go ahead and public defender represent you, so you have an attorney now. Any question about that?
No.
All right, sorry, on the meth, bond is 5,000. The paraphernalia is 1,000. The less than 20 grams of marijuana is 1,500. The offer to prostitute is 2,500, and you're held without bond on the VOP. Court date's going to be December 12th at 9 o'clock. Good luck, ma'am.
Step to your right to the T. When the green light comes on, sign. Next. Red X, ma'am. State your name.
Shively.
Shot for the court on a violation of probation, driving under the influence. You understand that charge? You understand the charge?
Yes, sir.
All right, ma'am. Your bond's at 25,000. Your court date's going to be December 4th at 1:30.
Step to your right to the T. When the green light comes on, sign. Next. You can bond out. And if you can't, then yes. Next. Bertram, come on in.
Yes,
Step on the red X. State your name.
Ronald Robert Bertram Jr.
Mr. Bertram, before the court, charged with possession of paraphernalia. You understand that charge?
Do what now? One more time? Can you
Do
say
you
it
understand
again?
what you've been charged with?
Not the seriousness of it. No, what's the seriousness of what the charge
First
is?
degree misdemeanor.
It's a first degree misdemeanor.
Yes.
Yeah, what it was, your honors, I found that on the ground and I washed and
Hey, now,
scrubbed that
talk
out.
about the fact of the case. Wait, hold on.
Go ahead,
Two
go
different
ahead.
things. Today's not the day to
Go
talk
ahead.
about the facts. Today's the day I need to make sure you understand the charge. I need to make sure
Yeah, I
that you
do.
understand your rights have been given to you and that you do qualify and you've applied for a public defender. So I'm going to appoint a public defender to represent you. He's going to tell you not to talk about the facts of your case. Right, Floyd?
Yes, sir. You need
Okay.
to wait and talk to your public defender about what happened. Do you understand?
Yeah. Go ahead.
Okay.
Yeah, criminal history.
He entered diversion on the first for trespass. 24, Louisiana, disturbing the peace. 21, out of Texas, felony tampering with a witness, felony obstruction.
How do you get charged with disturbing the peace in the state of Louisiana? That doesn't even make any sense. You don't go to Louisiana without disturbing the peace. Ain't nobody living in Louisiana is not disturbing the peace. Man, they've been crying about the football game for a week now. All right, Mr. Bertram, bond's 1,000. Court date's gonna be Monday, November 18th at 1 o'clock. Good luck, sir.
Step to your right to the T. When the green light comes on, sign. Mr. Clark refused to come down.
That hurts my feelings in ways that you can't even imagine. Mr. Clark's bond is preset at 1,500. His court date's gonna be Monday, November the 18th at 1 o'clock.
Next. Yep, sign with the light on. State your name, sir.
Mr. Williams, before the court, charged with petty theft as a second or subsequent offense. Do you understand that charge? I understand you've been given copies of paperwork and advised of your rights. Is that true?
Yeah.
Based on your application, finds you do qualify. I'm going to go ahead and appoint the public defender to represent you, so you have an attorney now. Any question about that?
No.
Deputy criminal history, Mr. Williams.
22 trespass, 20 battery, locally 19 DWLSR hit and run. Prior to that, nothing since 14. That was a less than 20 para resisting.
Bond 2,500. No contact with Walmart. Court date's November 18th at 1 o'clock.
Step to your right to the T. When the green light comes on, sign. Brawley also refused.
Oh.
He has no history.
273. Well, Brawley does not want a public defender. Like one of those. Set his bond at 5,000 and no alcohol. Court date's gonna be November 18th at 1 o'clock.
Yes, sir. Next. Red X, sir. State your name.
Timothy Ferguson.
Ferguson, for the court on failure to appear for a driving license been revoked, a failure to pay fine on a driving license been revoked, and a operating a motor vehicle without a license. You understand the charges?
Yes, sir.
I understand you've been given copies of paperwork advised of your rights. You've indicated you're going to hire your own attorney to represent yourself. Is that how you're going to proceed?
I need a appointed lawyer.
We need you
I
to fill out
can't
the
afford,
paperwork. Okay, we need you to fill out the paperwork so we can go ahead and do that for you.
Okay.
On the failure to appear for driving license been revoked, your bond's been preset at $2,500. Your court date is November 18th at 1 o'clock. On the failure to pay fine in front of Judge Grammer, you've been sentenced to serve 60 days in the Bay County Jail, but you may purge out upon payment of $750. And on the new operating a motor vehicle without a license, your bond is $2,500. Your court date is going to be November 18th at 1 o'clock. Good luck, sir.
All right, step to your right to the T. What don't you understand?
Can I bond out
You
today?
got a total of 5,000 in bonds plus that 750 on that failure to pay the fine.
I gotta pay
12, that's 1250. State your name.
Jeffrey Fallon, ma'am.
Mr. Fallon, you're for the court on a possession of an ammo by a convicted felon. You understand the charge?
Yes, sir.
I understand you've been given copies of paperwork and advised of your rights. Is that true?
Yes, sir.
Based on your application, you do qualify, and I'm going to go ahead and appoint the public defender to represent you. Any question about that?
No, sir.
This is an additional charge, ma'am.
Yes, sir. You gave him 100 yesterday.
Bonds 5,000, court dates December 23rd at 9 o'clock. Good luck, sir.
Yes, sir.
Step to your right to the T. When the green light comes on, sign. State your name.
This is Mr. Stone.
Yes, sir.
Mr. Stone, you're for the court on failure to appear for trafficking, meth, possession of paraphernalia in front of Judge Stevenson. You understand the charge?
Yes, sir. Judge, I had never missed a court date in my life. I was sick. I called my attorney. I tried to get working, reschedule it. I was very sick that day. All through the weekend. Monday was a holiday. I'd never missed no court date. Been doing pre-trial release, everything like I'm supposed to. I mean, I called and tried to get where I could reschedule it, and I was so sick I couldn't even lift my head up.
Okay.
My blood pressure was up, and I was throwing up real bad. I didn't want to go in a courtroom like that.
Been ordered held up on 4 days, November the 26th at 9 o'clock.
Step to your right to the T. When the green light comes on, sign. Next.
I didn't hear what he said.
Your court date, November the 26th. State your name.
Ricardo Palmer.
Mr. Palmer Sanchez, you're for the court charge of felony report, internet as a condition of registration, failure to change info on ID within 48 hours as a condition of registration, failure to report email or internet identifiers as a condition of registration, and violation of failing to report an email or internet identifier as a requirement by registration. As to all these charges, I understand you've been given copies of paperwork, advised of your rights. Based on your application, you make too much money to qualify for a public defender, but the law recognizes your financial situation may change, in which case you can reapply later. You also have the option of hiring your own attorney to represent yourself. Deputy Criminal History, Mr. Palmer Sanchez.
He has 3 of these from October, and all of these are related. He's on bond for the first 3.
Which I appeared in court yesterday. Rescheduled my court date for 12/12.
Were they all at the same time, or does this come later?
And all of them say 10/13.
Okay, gotcha. All right, bonds 5,000 on each case.
Come on.
Court date is December 12th at 9 o'clock.
All right, step over to your T.
Pare,
When the green light comes on, step on the X.
pares en la X.
It's 4. 20.
Where are we?
Hello, Your Honor.
They finally released you out of my arraignment docket?
Yes, sir. It took a little bit longer than expected.
That's okay. All right, you're still under, this is Mr. Figure, just ask him to say his full name. Ask Juan to say his full name for me.
Juan, dígale su nombre completo al juez.
Montanos Figueroa.
Mr. Figueroa, possession of meth, a violation of probation for possession of meth charge.
Señor Figueroa está frente al juez por incumplir su libertad vigilada en un cargo de posesión de metanfetamina.
Based on this application, it does qualify, and I am going to go ahead and appoint a public defender to represent him.
Según su solicitud, determino que califica y le asigno al abogado de oficio para que lo represente.
Judge Clark, his magnificent hair and infinite wisdom, has ordered that he be held without bond. His court date is December the 18th at 9 o'clock.
El juez Clark, en toda su sabiduría, ha determinado que a usted se le mantenga detenido sin fianza. Su próxima audiencia es el 18 de diciembre a las 9 en punto.
Buena suerte.
Thank you.
Step over on the T.
Pase a un lado encima de la T.
No. Before you go, Jordani, how do you say roll tide?
Bye, Jordani. Have a great weekend.
Thank you, everyone. Have a great weekend.
State your name.
Oh, Mr. Edwards, before the court on failing to appear for grand theft auto ×2. You've indicated you've already got an attorney, or you're going to hire your own. Is that how you're going to represent yourself?
No, sir, I was gonna get a public defender.
We need you to fill out the paper then so that we can make a determination if you qualify. Has he been screened for the ankle monitor program?
Oh.
Well, it says on here that Judge Garcia says maybe release the Bay County ankle monitor if he qualifies.
Okay.
That's pretty nice for a fellow to appear. That's very lenient, Judge Garcia. Shocking. Need to talk to her, see if she was feeling okay that day. So ankle monitor or hold without. Court date's going to be December 5th at 9 o'clock.
Step to your right to the T. When the green light comes on, sign. Red X, sir. On the X. State your name.
Sean Anthony Day.
Mr. Day, you're fully court charged with grand theft. You understand the charge?
Excuse me?
You understand what you're charged with?
Yes.
I understand you've been given copies of paperwork and advised of your rights. Is that true, sir?
Yes, sir.
All right, Mr. Day, you've indicated you're going to hire your own attorney to represent yourself. Is that how you're going to proceed?
Yeah, hire my own attorney.
Excellent. Deputy criminal history, Mr. Day?
21 DWLSR controlled substance tampering with evidence, FTA para VOP with a DUI in 20, and that's it.
But I didn't
All
get
right.
convicted of.
It's your arrest
Nobody
history.
Okay.
Bond set at 5,000. Court date's December 12th at 9 o'clock. No contact with the alleged victim.
Step to your right to the T. When the green light comes on, sign. Next. Red X, sir. Step on the X right there. Face the TV. Well, don't fall. Face the TV. Exactly. Say your
Mr.
name.
Wynn, can you hear me, Mr. Wynn?
Yeah, I will.
Mr. Wynn, you're fully court charged with fleeing and eluding with lights and sirens, theft, and resisting officer without violence. Do you understand those charges?
You understand what you're charged with? Hold on. Mr. Vann, have a seat right here. Now, do you understand what they charged you with?
I don't know.
All right, he does qualify for a public defender. I'm gonna appoint a public defender representative, so he's got an attorney now. Deputy criminal history.
Nothing since, looks like,
I'll put
hold
nothing.
on. Huh?
I'm good. I'm good. If you gotta go that far back, I'm good.
No, it's
Pretty try-
18. I was just trying to make sure where. His VOPs and everything.
Okay. I'm still gonna pre-trial release him.
Okay.
His court date for felonies is gonna be December the 23rd at 9 o'clock, November the 18th at 1 o'clock.
Okay.
I'll
You're
send
gonna
that
get
one.
out next.
Floyd, you might wanna highlight whoever's got that case. There might be some issues.
Step on the X. Yeah, get that in. Say your name.
Robert Control.
Struck full court for possession of fentanyl, possession paraphernalia. You understand the charge? I understand you've been given copies of paperwork and advised of your rights. Based on your application, I find that you do qualify. I'm going to go ahead and appoint the public defender to represent you. Any question about that?
Sure.
Okay. Deputy criminal history.
Got him on bond on a reckless controlled substance less than 20 impair.
Case number.
24, 2867 CF.
All right, Mr. Tetrall, bond set at 10,000 on fentanyl, 1,000 on paraphernalia. Court date's going to be December 2nd, 9 o'clock, and I'm revoking release in 24, 2867. Good luck, sir.
Step to your right to the T. When the green light comes on, sign. Ready, sir? State your name.
Brad Smotherman.
Mr. Smotherman, you fully court charged with burglary and unoccupied dwelling. Do you understand that charge?
Yes, sir.
I understand you've been given copies of paperwork and advised of your rights. Is that true?
Yes, sir.
Based on your application, I find that you do qualify. I'm going to go ahead and appoint the public defender to represent you. Any question about that?
No, sir.
Deputy criminal history.
Alabama 23, marijuana disorderly controlled substance para. Locally 23, less than 20 para, attaching a registration.
Bond set at 15,000. Court date is December 12th, 9 o'clock. No contact with the alleged victim.
Step to your right to the T. When the green light comes on, sign. Next. Ready, sir? State your name.
Dana Peeler.
Mr. Peeler, you fully court charged possession of ammunition by convicted felon, possession with intent to sell or distribute marijuana, and possession of paraphernalia. Do you understand the charges?
Yes, sir.
I understand you've been given copies of paperwork and advised of your rights. Is that true?
Yes, sir.
Based on your application, you make too much money to qualify for a public defender, but the law recognizes your financial situation may change, in which case you can reapply later. You also have the option of hiring your own attorney to represent yourself. Jeff, you criminal history, Mr. Peeler?
Got a FTA this year. Prior to that, nothing since,
2019. Get that.
14, that was cocaine and para with VOPs through 19.
Bond set at 5,000 ammunition, 5,000 the pot with intent, 1,000 the paraphernalia. Court date's gonna be December 23rd, random UAs, 9 o'clock.
So I gotta have real UAs until I go to court?
No.
That's what you saying, sir?
Court.
While you're at court.
Oh, while I'm going to court?
Mhm.
It's gonna be random UNAs? Okay.
Wait, step on the T. When the green light comes on, sign. Next. Next, Red X, sir. State your name.
Mr. Hill, you fully court charged with fraud. Do you understand that charge?
Not fully.
Well, they say that you kept shorting the deposits of Burger King. Now, do you understand?
Okay, I'm listening.
I understand you've been given copies of paperwork and advised of your rights. Is that true?
Yes, sir.
Based on your application, upon you do qualify, go ahead and appoint the public defender to represent you. So you have an attorney now. Any question about that?
No, I don't have an attorney.
He just gave you one.
Okay.
That's what I did. Deputy, criminal history?
Nothing says 2008, and that was a fraud.
Was a fraud?
Yep, insufficient funds.
Onset at 5,000, no contact. Court date's gonna be December 16th at 9 o'clock. Good luck, sir.
Step to your right to the T. When the green light comes on, sign. Next.
Mr. Seaborn, how you doing, sir?
How you doing? He asked him.
Oh, yes, I'm doing good, sir. Sorry.
Good. Mr. Seaborn, you fully court charged with attempted sale of fentanyl, use of a two-way communication device during the commission of a felony, possession of fentanyl with intent to sell or distribute, altering or tampering with physical evidence, and a paraphernalia. Do you understand those charges?
Yes, sir.
I understand you've been given copies of paperwork and advised of your rights. Is that true, sir?
Yes, sir.
Based on your application, you do qualify. Go ahead, point the public defender to represent you. Question about that.
Yes, sir.
Yeah.
21 meth para VOP. 20 use of a two-way meth with intent para, controlled substance para. 19 FTA times 3. Controlled substance para. It goes back locally to the 90s.
On the intent to sell of fentanyl, bond set at 7,500. On the use of a two-way communication device during the commission of a felony, bond set at 5,000. The possession of fentanyl with intent to sell or distribute is 10,000. The tampering with physical evidence is 5,000. And the paraphernalia is 1,000. Court date's going to be December 16th at 9 o'clock at random UAs. Good luck, sir.
Step to your right to the,
Random UAs. Right here.
when the green light comes on. Mhm.
All right.
Careful, bond.
State your name, sir. There you go.
Is there any court order
Right here.
obstructing justice? That's one of those catch-alls. Domestic violence, battery by strangulation, and domestic violence battery. You understand the charges, sir?
Yes.
I understand you've been given copies of paperwork and advised of your rights. Is that true, sir?
Yes.
Based on your application, I find that you do qualify. I'm going to go ahead and appoint the public defender representing you. Question?
Yeah, I might get a different attorney, but I don't have one right now.
Okay. Well, you certainly have the option of hiring your own at any time.
Okay, but are you gonna, are you gonna appoint one to me?
Just did.
Oh.
Deputy Magistrate.
Out of Illinois, 21 domestic, 19 DUI, DWLSR times 2, and contempt. 16 was a DUI, DWLSR.
All right, on hindering communication info to police, bond set at 5,000. On the domestic violence battery by strangulation, 10,000. On the domestic violence battery, 5,000. No contact directly, indirectly, or through a third party. Alleged victim. Court date is December 12th at 9 o'clock. Good luck, sir.
All right, step to your right to the T. When the green light comes on, sign. Next. Red X, sir. State your name.
Lamar Anderson.
Mr. Anderson. Mr. Anderson, for the court on violation of probation for what was originally felon in possession of a firearm, forgery, possession of methamphetamine, possession of more than 20 grams of marijuana. You understand those charges?
Yes, sir.
You've been ordered held out bond. Your court date is December 18th at 9 o'clock. Good luck, sir.
Yes,
Step,
sir.
wait. Step on the T. When the green light comes on, sign. Next. Anderson. Red X. State your name.
Mark Stephen Anderson.
For the court charge trespass times 2. You understand those charges?
Yes, sir.
I understand you've been given copies of paperwork and advised of your rights. Is that true?
Correct.
You've indicated you don't want a public defender. You want to represent yourself, sir?
Yes, sir.
Okay. Set your bond at $2,500 on each charge. Court date's going to be November 18th at 1 o'clock. No contact with the alleged victim. Good luck, sir.
Step to your right to the T. When the green light comes on, sign. Next. Red X, sir. Step on it. State your name.
Justice Lewis, deal the second.
Mr. Diddy, for the court on a possession of meth charge, a loitering and prowling charge, and a violation of probation for what was originally burglary, dealing stolen property, grand theft firearm, grand theft automobile, grand theft, and false verification of ownership. Do you understand the charges?
Yes, sir.
All right, sir. Based on your application, I find that you do qualify. I'm going to go ahead and appoint the public defender to represent you, so you have an attorney now.
Okay.
I'm going to set you a monetary bond on possession of meth of $5,000, on the loitering and prowling at $2,500. You've been ordered held without bond. DOP. Your court date is December 12th at 9 o'clock. Good luck, sir.
Step to your right to the T. When the green light comes on, sign. And that's a wrap.
It's been a good 2 weeks.
It really has, but this week been just trying.
As you see on the screen, ladies and gentlemen, it's time for River Ridge versus Tom Kelly and his motion to set aside default.
Court calls the case of River Ridge versus Timothy Kelly.
Rachel Dornbush, Your Honor, on behalf of the plaintiff.
Your name, sir?
Timothy Kelly.
I have two motions up. I have your motion to set aside the default.
Put the picture of my daughter here. She's an occupant. She wanted to be here to say something, but she was in school.
Okay.
Thank you.
No, sir, that picture is not gonna happen that way. You're not gonna sit up there and display things to the court that way.
Okay, I asked first. I'm sorry. I've mentioned her a lot, so I just wanted you to see her.
All right, let's deal with your motion first, Mr. Kelly.
Okay. Come on, Your Honor, did you get the evidence package, the exhibit evidence? I asked the girls when I walked in, girls, I mean the nice ladies up front.
I have these picture exhibits. I don't know if Ms. Dornbush has them or not, but
No.
I have.
Okay, you do have them?
Your Honor, I do not have them, just so the court is aware.
All right. I thought they were both sent because I have a double thing where you could send group, and I sent them. At any rate.
Okay. All right.
Your Honor, I just, with due process, the most important thing is being heard, and I haven't been able to be heard yet and state my case and defending myself with all these accusations. And, you know, that's why I know I missed the trial, but there's all kinds of things, reasons for it. I've met all the demands of the court. If you remember, I was before you for 4 or 5 months in a row dealing with the rent, and we made decisions and I lived up to the demands and so on and so forth. So I did you read the motion where I gave you?
I have read everything that comes in this.
All right. I didn't know. I'm just, you know, I want to have a trial.
Sir, I gave you that opportunity to have a trial on October 30th, and you failed to appear.
I know, but fails to appear sometimes happens. Can I read something to you, Your Honor? This is all diversion programs and sent down by the Attorney General to try and help tenant landlord disputes. that a judge could take a proactive role in the hearing by ensuring that both parties
Sir,
know.
what are you reading from?
It's recommendations from, we never even got a chance to talk or settle. I mean, we had a last settlement conference, but we didn't talk about anything. And before that, the attorney and the landlord, or I'm sorry, the property manager kept me from talking to him. We couldn't even try and settle. And throughout the whole thing, all the legal stuff that I read is that you try and work it out before the eviction case. And also I have, this is for sure a retaliatory eviction, and you wouldn't even let me speak on it the one time I brought it up because.
Sir, you know what?
What? If you give me a trial, Your Honor, did you read the character references my neighbor sent you?
Do not.
The Mitchell.
Do not come here.
What?
At this hour, questioning me.
I'm not
about what you think I haven't read. I have just told you that I read everything in the file.
I apologize.
Do not come here before me, because all of these people have been sitting here, they've been here, and tell me ever that I won't give somebody an opportunity to be heard. Do not insult this court that way. Do not insult me that way. Now, if you want to start your argument again, you may, but you will not sit here and impugn the character of this court or of me with regard to listening to tenants and landlords regarding these proceedings. And you will not attempt to try to school me with some literature as to how to handle a case. I have been doing, you know what?
What?
I'm gonna pass this case and because I want to make sure that I'm listening to you. And I don't think these other people that are sitting in here should have to wait through your shenanigans. So have a seat.
I'm confused, Your Honor, please. I didn't say it was you. I said due process. That's all I said.
Have a seat.
I wasn't saying anything.
Have a seat and keep your mouth closed. You throw something down again, we're gonna have a problem. Will you throw something down again, we're gonna have a problem.
Sorry.
Case of Spice Street Apartments versus Haley Salisbury. And Gavin Westlaw. Haley.
For the record, Rachel Dornbush, Pallets Law on behalf of plaintiff, Your Honor.
All right, you were to make some decisions. What are we doing?
Well, let me just start, Your
Go
Honor,
ahead.
by just saying, we're prepared to dismiss this case. My client has received the escrow check. Ms. Salisbury's rent is paid in full and then some. And so I don't know that the exact dollar amount will get her through December because the water sewer charge isn't exact, but it should be pretty close. And then I believe following this, Ms. Salisbury and property manager can discuss her options going forward and what her intentions are now that everything's caught up.
That's your understanding, young lady? Okay. All right, then what I'm gonna do, I'm gonna dismiss this case.
So just to catch everybody up, so the GoFundMe went through. There was some tribulation about how much money the facility was going to withdraw from the escrow because they had enough money to pay off the whole year. But there were some thoughts that maybe Haley didn't really want to stay at that location for the rest of the year. Her whole thinking is, if they want me gone, I just want to leave. So what's happened now is they've paid through the end of the year, not all the way through till next summer. And she has the option to leave if she wants to leave. So everything is fully in her hands moving forward.
All right. That's without prejudice. I'm gonna order that the trust balance be refunded to the defendant in this case. Well, to specifically to you. Okay. So since we have two defendants on here, Miss, well, then can we make sure that they're clear? I'm going to put it in the file that it will be to Haley. That being defendant one.
Yeah, it's posted correctly, so.
It's posted to, it's posted to her, so if I just tell them to refund it, they'll only give it to her. All right. Haley, good luck to you.
Thank you.
Uh,
Do I go over there to the clerk
And get a check?
and ask them, or
Sure, you can ask them. They're probably not gonna,
Oh,
they're
yeah.
not gonna write you out a check today, but
is that how it works though, or do I need to do anything?
yeah, they'll either give you a check or mail it out to her, right?
They will mail it.
Okay.
They'll cut it sometime next week.
Next week, and they'll mail it to you, okay?
Mhm.
It's good?
Mhm.
Haley, do me a favor. Take care of yourself, please.
I will.
All right, be happy, and always realize that with all the dark things and everything that happen in the world, that there comes a point where sometimes good things can happen, and you just never give up faith.
Mhm.
All right?
Okay, thank you.
Take care.
You too.
Let me retry this. Court recalls the case of River Ridge versus Timothy Kelly. This is your motion to set aside the default judgment. There are two parts to the setting aside of a default judgment before you start going on. The first part is that you have to have good cause for failure to appear. State every reason for your good cause for failure to appear for the trial.
Oh, you want me to state it now?
I asked the question.
Okay, I'm sorry. I thought you were making a statement. Well, as I iterated in the motion, that one, I don't have transportation. It's very hard to get it. I don't have the money for an Uber or a taxi or any of that. If you recall, I told you, for one of the hearings, I rode my bike 30 miles round trip. So it's not that I wasn't trying to get here. And I also, right from the beginning, everything I've told you has been the truth. I mean, in the beginning of we had trouble with the rent. I told you that I was also going through litigation with a friend of the court. And as a father, that's a very hard thing to figure out and such. So that's one of the reasons was my daughter called me that night. She had an emergency and I had to take care of it. And she was with me the next day, the trial day. And
we received no notification or phone call from you indicating that there was some delay or some reason why you couldn't be here that day. Is there a reason why you didn't call the court?
Yes, and I'll tell you, that week I had dropped my phone and it broke, and I had no way to call anybody. I didn't have any way to get any of my trial stuff out. I couldn't access anything. I didn't have the money to buy another phone. So for 4 days, 5 days there, I was in purgatory, so to speak, without being able to communicate, without being able to get anything off the phone pertaining to the trial or this case. And that's the truth.
You mean you couldn't have found a place to call from?
Pardon me?
You couldn't have found a place to call the court from?
Yes, well, I was in the middle of this. Look at my child. I don't want to put it on record yet because has to do with some serious things going on with her safety wise. So, and I didn't know, it's very hard I don't want to, can I ask you a question about the trial? I mean, I don't want you to think I'm questioning your judgment, but I'm confused about why it was set on to the bench when I demanded a jury trial way back.
We have already gone through this. You failed to comply with the escrow order. Plaintiff was entitled to a trial as to the issue of possession, an immediate trial. I set it out a few days. We have been through this. I'm not relitigating everything, nor answering all of the questions that I've asked, that I've answered for you in the past, Mr. Kelly. I'm just not doing it.
I don't recall us talking about whether it was going to be a bench or a jury. Honest, Your Honor. And I've
Your Honor,
met,
I can state the exact date that this was addressed because I specifically emailed the court to clarify if the jury was waived and was able to verify. So I can remind the court the exact date that that conversation happened.
I thought at that time that it was a.
I'm not going back over this.
Your Honor, if you would listen to, if I could cross-examine witnesses and bring my witnesses in, you'd see a different light on this, I swear. I haven't been able to present anything. You don't, I mean, may I ask you another question that I don't get? I'm not questioning you, but I wasn't there and I don't understand how it came to the trespass and the witnesses that I can't go around them. What was said that you think I'm a danger to the community?
It wasn't an issue of you necessarily being a danger to the community. They were trespassing you after the writ would issue. It's as simple as that.
Okay, well, I mean, those were a couple on the list were friends. I mean, I get along with Kevin, and so I didn't understand why I was out, you know, but it was a good reason. I want you to know the facts of the case. That's all.
The second thing is that you have to state to the court a meritorious defense. Please state your meritorious defenses, Mr. Kelly.
Well, can you help me out with the meaning of that more?
No.
No? Okay. Well, you know, I know have a right to counsel, but all the resources are used up. I have tried for since this case began to get some help from the state and all the resources that are listed, you know, and they're all filled up. I think it's hard to even express because I'm afraid I'll offend you. And
sir, do not try to blame me.
I'm not blaming you
this
at all.
You just need to say what you're going to say.
Okay, well,
I don't think that there's anybody that comes before this court that would at all indicate I don't listen. I may not agree with you, but I will always listen. So don't try to put it, poor me.
No.
Somehow this judge won't listen to me.
I'm not.
Say what you have to say, and then I will make my decision.
Well, I had all kinds of things written down. I started to read it, and you said, "Don't read that to me." Well, I don't know how to present. Can we go over the evidence? May we do that? I marked all the.
Your Honor, I would object. I've not seen this evidence that Mr. Kelly is referring to. It certainly wasn't attached to the motion that I received. I don't know when it was filed with the court, but I've not seen this evidence to be able to comment, to be able to prepare any sort of response to it.
It pertains to my oral argument already on the record, Your Honor.
I'm going to sustain her objection. You can't come here with new things expecting for the opposing side to respond to them.
Well, I was going to fill out.
It doesn't work that way.
Okay. I was going to fill out an amendment to the motion, but I've been up all week, all night trying to just get the proper paperwork into you and do it all right. It's not easy being 95% of us tenants don't have lawyers. We're pro se. So, I don't know where to get any help as far as the legal, but she has been able to bring the list of the original offenses. She's added on to that throughout the trial. The plaintiff has. I mean, now my dogs, first it was just 4 items. And she's brought up my dog. So she's added on without. So I'm just confused about the way to present evidence, I guess. I mean, she brought up my daughter missing a day of school. Where did that come from? I mean, all
I
of
didn't
those have
mention
been,
his daughter at all, Your Honor. I'm sorry. When
it's
did
in
I
the,
mention his daughter?
it's in the transcripts. I can't pull it up right now, but it's there because it bothered me. Honestly. I mean, I don't know how to present to you. Why don't I get to present the retaliation defense? You haven't listened to what
Sir,
happened there.
I need meritorious defenses you have to this claim.
You can't tell me what, may I look the word up in my phone?
If you can do it quickly, you can go ahead and do it quickly.
Never mind. Okay.
No, go ahead and look it up.
Your Honor, Mr. Kelly is retrieving his phone. I just want to make the court aware that I would like an opportunity to respond to.
Oh, absolutely. As soon as we can get there.
What's the word, Your Honor?
Meritorious.
Meritorious. Could you spell it for me?
No.
Okay. See. Oh.
You filed the motion.
Yeah, probably should have paid attention to that.
Yeah.
Well, it's hard. I've been reading everything in the law. It's the only way I can do anything. And there's a lot to take in, Your Honor. The delay, suspension of an act. Oh, okay, I know. I did read that. That's kind of like what they did for COVID with the money. Do I have that right? Sorry.
I don't know what you're talking about.
Well, I
have no idea.
Is it moratorium? I'm sorry. Okay. My defense is that I just want to be heard. And I didn't say that you did anything wrong to make that not happen. But with reading all the stuff in the legal that you have to read if you're pro se, you know, I'm not an attorney, but I'm starting to at least learn some of the laws between tenant and landlord, and everything I read is the land of America is trying to the courts handed down by the Attorney General and the Supreme Court on helping the litigants, especially the tenants, because they're the ones that are come to you with no resources as far as money for an attorney or any of that. And the landlords always have the best attorneys. Like I said, 95% of us are pro se. So all I can do, and I told you an attorney called from Michigan Legal Help, but he just left a message and never got back to me. And so I have to read on these motions and read on the appeals or read on how to go about a defense. And when I present
No, come back. Okay, well, can't, no, I was gonna make, I think you should stay too. Go ahead.
When I'm trying to present the retaliatory eviction, there's all kinds of writings on that in the law. So it must be something that happens in court or they wouldn't have it in there, correct? I mean, I'm not a bad person. I want you to know the truth, Your Honor.
I'm not saying you're a bad person. Miss Lee, you have a reason. Is there a reason?
I'm sorry, Your Honor. I did want to corroborate Mr. Kelly's account. He did get in touch with our hotline, our housing intake line. We have been trying to give him advice over the phone, but we do not have the resources to represent him. If you would like me to sit with Mr. Kelly for a bit and try to assist him a little bit further, I'm happy to do that.
Okay. If you're willing to do that, Ms. Dornbush, I'm sorry to hold up your evening, but I will allow it to happen because I'm probably one of the most unfair judges I've ever met, but I'm gonna try to be fair. Mr. Kelly,
Can I-
step away from the podium?
May I give you a
No,
compliment,
no,
please, Your Honor?
No,
Okay,
do not give me a compliment. Do not say anything to me at this
all
time.
right.
I'm gonna handle Mr. Fink's case as Ms. Dornbush. Sooner or later, you'll be able to go home.
Okay.
She's gonna be mad at me.
I would never dare.
I tried. River Ridge versus Timothy Kelly. If Ms. Dornbush.
I am still here, Judge, yeah.
I've called the case. What are we doing?
Well, Your Honor, as far as what you asked me about the defense, I just want to make a notation at the bottom. It says, upon information relief, resident has failed to remedy the violations after being given an opportunity to cure. Thus, grounds for termination exist. I did cure all of them at the time they asked. Every time they ever asked, it was always, I always met their demand, whether I liked it or not. So I would like an opportunity to go to trial and defend this and show you that. And as far as any verbal abuse, I put in one of my letters that, or one of my motions that somewhere there's a phone call of that, because it was a three-way conversation, and I didn't know if I needed to look it up or not. But as far as the upon information belief and all those lists, please, I deny them, and I can go one by one if you want. I'd just like the opportunity to show you and cross-examine witnesses if there are any, trying to accuse me of this. I adamantly deny most of what's on here. I mean, there was the car, we talked about it, on the grass, but that was during the settlement conference. During what I was just trying to explain to you is that's not how it was. It says parking on the lawn on or about. That car was on the lawn for about 3 months, and then she asked me to move it to the drive. We pushed it to the drive, and then it finally got towed 3 months later for expired plates, because the car wasn't running at that, but it had legal plates up until that point. So that's all I was trying to explain that one day about the car when, the final settlement conference. I wasn't disputing that at one point it was on the lawn, but it's kind of, and I don't know how that works, but I do have witnesses for most of these to dispute them. And I don't know if you have that in front of you, but doesn't that read like if the cure was given, that there wouldn't be grounds for termination, or am I reading that wrong? Because I did cure everything they've ever asked me to do as far as moving.
All right, Ms. Dornbush, your response.
Thank you.
Oh,
Your
I'm
Honor.
sorry, I don't have.
Go ahead.
I'm waiting for Mr. Kelly to get his hearing device.
Thank you.
Okay.
Your Honor, at the outset, when Mr. Kelly first began speaking, he made a statement that he has complied with all demands of the court. And I want to first address that statement because that's absolutely false. Mr. Kelly has not complied with all the demands of the court because he was ordered to do several things early on and he did not do any of them timely. Most recently, he did not pay the full October rent into escrow. He did not pay November rent into escrow. He did not pay rent into escrow with the motion that he filed, even though he checked the box stating that he did. He made a statement, Your Honor, that there was no opportunity to settle this. That is also false because Mr. Kelly and I had a very lengthy conversation back in August, at which time we did attempt to settle this, but the settlement offer that I was authorized to make was not something that Mr. Kelly was satisfied with. The only settlement that Mr. Kelly wants is an agreement by my client that he can stay. And that's not something my client is going to agree to. And I made that very clear to Mr. Kelly. Your Honor, with respect to Mr. Kelly's motion and his statement that he has good cause for his failure to appear, he put many things in his motion, Your Honor. I would say the majority of them have absolutely no relevance to the issue of good cause. That is delineated in the response that I filed with the court. And Your Honor, just for Mr. Kelly's awareness, there was a glitch in our system, and the address that I mailed my response to, which it went out day before yesterday, so we probably wouldn't have been delivered by today anyway. It's not going to go to him. So with his permission, I will email him a copy of it if he wants it for his records. I'll stick it in the mail as well, because I do have his email address.
Okay, yes, well, you have the court's permission to do that, understanding what you did.
I don't have a problem.
Thank you, Your Honor. The specific issues that he put in that I believe have absolutely no relevance to the issue of good cause is that the court being aware of his transportation issue and his having to ride a bike to the court previously, he somehow managed to get here every time. Further, for this specific motion, or excuse me, the trial date, Your Honor, Mr. Kelly stated he had a ride lined up and he chose not to take the ride because of another reason, and we'll touch on that in a moment. But he had a ride lined up, and he has a ride today, I believe. My client's here and sees that there's another resident in the community that she believes may have driven Mr. Kelly to court today. So clearly he has the ability to get transportation here. As the court noted, Mr. Kelly didn't call the court, and Mr. Kelly made a statement that his phone was broken. But Your Honor, I seem to recall, and maybe I misheard, but in this hearing, when questioned about why he didn't call the court, he said he didn't have a phone. But just a minute before that, didn't he say that his daughter called him about an emergency?
The night before.
Daughter was able to call him the night before. If his phone was broken for the 3 or 4 days before that, somehow he didn't have a phone the morning of court to call. But not only that, he's obviously got people in the community that are there to support him. As the court pointed out, he could have borrowed a phone from anybody. So I don't believe that Mr. Kelly has stated good cause. For the additional reasons stated in my motion, Your Honor, he stated his belief that he'd be given a break because default was a possibility, may enter. But Your Honor, Mr. Kelly's been in court before and failed to appear, and a default judgment was entered against him. And I referenced that particular case number in my response. Your Honor, he referenced his concern related to his alleged request for a jury trial, but the court has already touched on that. And Your Honor, the date, just for the record, that that particular issue was addressed was September 20th of this year. He cites an alleged case with the Michigan Civil Liberties Department, and I assume he means the Michigan Department of Civil Rights when he states that. Again, has no bearing on his good cause for appearing at the trial date. That he was finally in touch with an attorney from MI Legal Help. Again, no bearing on his good cause for failure to appear, and that he intends to file appellate pleadings. Again, no good cause for his failure to appear. Your Honor, this emergency with his daughter, I'm sympathetic to whatever's going on in his family situation, but Your Honor, Mr. Kelly has been stating various times throughout these proceedings that this alleged custody issue has interfered or detracted from his ability to meaningfully engage in this court process. And Your Honor, I personally did a search of the Circuit County Register of Actions. I don't see anything pending in that case. My understanding from what's available on that Register of Actions is that Mr. Kelly's ex-wife has sole legal custody of his daughter. And one of the police reports that we were able to obtain from the Michigan State Police, and I believe it's from sometime last year, I don't have the exact date, that there has been no change in that. They specifically referenced that his ex-wife has custody, full legal custody of his daughter, and that there's been no change to that. If there's been some change between 2023 and now, Your Honor, it's not showing on the Register of Actions, but there's nothing pending showing in that case with the Washtenaw County Circuit Court. Your Honor, with respect to this alleged meritorious defense, first off, we've already addressed at the settlement conference before Mr. Kelly was taken into custody for that bench warrant, why additional things were added and more specifically stated in our complaint for termination of tenancy. And that is because the demand that was issued, Your Honor, states reserves the right to bring this and other issues that are least violations to proceed on the termination action. And so at that court date, Your Honor, which was approximately 3 weeks ago, Mr. Kelly had notice of what additional grounds would be relied upon by plaintiff. One of those issues was an actual admission by Mr. Kelly with a photo he provided to the court of his dog sitting outside on a tie out. Community doesn't allow that. And frankly, Your Honor, the dog was tied out again today. Mr. Kelly nowhere in sight. My client is signed into Zoom right here, and she could tell the court that, again, the dog was tied out. Mr. Kelly was not out there with him. Minor violation of the rules, Your Honor, yes, but it's just a continuation of Mr. Kelly believing the rules don't apply to him, Your Honor. And that's unfortunately been how this process has gone throughout. Every time the court has ordered Mr. Kelly to do something and he didn't follow through, there's just been some reason why he should be given leeway and that he shouldn't be bound by the orders of this court, the rules of the community, the laws of the state of Michigan, Your Honor. Speaking of those laws, Mr. Kelly has still yet to state any defense to his driving in the community, probably since 2017, without a license. The lease that he signed clearly states he is to be in compliance with the laws of the state, local ordinance, federal law, and Mr. Kelly is in violation of Michigan state law by driving without a license in the community. He's been living there since 2017, and I believe he acknowledged at the settlement conference on the 22nd of October that he hasn't had a license since 2017. So that on its own is sufficient grounds for this court to grant a judgment of possession. And I believe Your Honor even alluded to that at the last court date and still gave Mr. Kelly the courtesy of having an opportunity to appear for a bench trial and bring his witnesses. With respect to this alleged retaliation or retaliatory eviction, Your Honor, the statute is very clear on what constitutes retaliation, and Mr. Kelly has yet to cite anything in that statute that my client, that he has done that would bring about a claim of retaliation by my client. But even if he had, Judge, that is a rebuttable presumption. And my client would still have the ability to show that they have legitimate grounds to terminate Mr. Kelly's tenancy. Your Honor, at that settlement conference, it was discussed how Mr. Kelly's answer was deficient for a number of reasons. One of those things being that he in no way addressed the specific issues that were referenced in the termination of tenancy notice, that being the animal loose in the community, disturbing other residents, parking on the lawn, failure to maintain the home and site, verbally abusive towards management. He's addressed a few of those things today, Your Honor. And my client would acknowledge today that certain issues with respect to violations relating to condition of the site were addressed. But as we discussed at length at the October 22nd hearing, Your Honor, with respect to the vehicle, it sat there for months after violations. And Mr. Kelly didn't do anything about it. My client had to ultimately have the vehicle towed. So there's a violation right there that there's clearly no defense to. With respect to the verbal abuse of management, Your Honor, how do you cure that? You can't go back and take the words back. I mean, it happened. So that's not really a curable thing. With respect to disturbing other residents, that's something that continues to happen.
That's not true. I mean, that's just a statement.
Mr. Kelly, I didn't interrupt you.
Oh, I'm sorry. I can't talk. I thought you were done. I'm sorry.
You will have an opportunity to respond. But Your Honor, we talked at length on October 22nd about how Mr. Kelly's answer was deficient because it didn't address those things. And in filing his motion, Your Honor, he still doesn't address those things. The only things that he brings up is this alleged audio recording that he thinks will prove retaliation. But that's not going to be sufficient. The statement that he's provided does not give any detail, which is the issue that was precisely stated at the hearing on the 22nd. And Mr. Kelly is still not following the rules and now expects the court to give him leeway again. The court has already done that by setting the matter for a bench trial on the 30th. Mr. Kelly's own motion, Your Honor, clearly states, I made the decision not to come to court because I didn't want to bring my daughter. He made a calculated decision based on the circumstances not to come to court. And he has not set forth anything in his motion that should change that outcome. Respectfully, Your Honor. And so I have to ask that this court deny his motion and allow the judgment to stand.
Your Honor, I want to address the motion itself. She had brought in I meant to put that under the ex parte where I marked the money to go into escrow.
But there was no escrow filed.
No, there wasn't, but there was a box. Your Honor, when I was before you, it was, you know that I have money problems. I have a fixed income coming in every week, every month. And when that comes in, I can pay any arrearage. I mean, and that's what I was speaking to when I met the demands, when only in the money, I wasn't talking about here, but when I went before you, I've been going before you for the last 4 or 5 months before the just cause. And what I was saying was that, you know, when you said pay on this date and the court said we did, except the one time when I was $43 short, which she'll probably bring up. And regarding the settlement agreement, I was going through these. In fact, I was on the car on the lawn discussing it and speaking to you, Your Honor, when you discovered the warrant thing, and then I was taken out. And when I came back, we didn't discuss anymore. So, I mean, I don't know how I can address it better than that. We were addressing it and going down the list, but then I didn't, I didn't get to, but, it's kind of hard. I'm trying to follow her. Some of these things, she says that in my answer, I don't explain things. It's kind of general. Well, this stuff doesn't either. It just says that, she's stating that the abuse and threatening of staff, I have yet to hear, what are you talking about? I mean, we can all throw out things out there, but what did I say? Who did I say it to? What was it? Because I can remember that conversation and the incident because that coincides with the electrical cord. So, I mean, I mean, these are kind of vague too. I don't know how to defend them, but there is the reason there's a civil right, and I did put the letters wrong, but as far as the Michigan Department of Civil Rights, that I do have a case number or a complaint number, and that's for the very reason that I've been trying to explain to you about the differences in her, her writing me up, or the landlord or the property manager writing me up and not writing the neighbor up for the exact same thing. I mean, that's listed in discrimination by the state of Michigan. I read it, and it uses an example like that. Like if you have a resident here or a tenant here that is late for their rent, and you go in and make a move on them, but across the street is the same exact thing. They're late on rent, but you don't there. That's a civil infraction from what I've read, or it's discrimination. And that's what's going on here. That's why I kind of brought in, sent those pictures to you. I mean, and as far as the day I missed, that was a terrible week. It was my responsibility. I say that in my motion that I got cuffed and thrown in jail. But, I get home and I'm on this website that I've never seen before. My daughter brings it in, and it's you, and it says contemptuous defendant goes out the back door. And gosh, the comments were brutal. I mean, brutal. It's not up anymore, but it was, and my daughter actually answered to some of it. So that week was just brutal. But I said that about my daughter because and the neighbor that drove me here, he's left, so I'm stranded again. But he will attest that we were ready to. He was my ride. He usually is, and his car's in the driveway right now. It broke down, and I did try to get other rides, but everybody's at work at that time of day. So what I meant in that was I did have my daughter. If I do get a ride, I got to take her. I wonder if
but you said you had made a decision not to.
Well, only because I didn't know if it was allowed at the
No,
court.
no. You're telling me you had this and this is what you would have done. But your motion says you had made a decision because of your daughter not to come to court.
With
Can't
her.
have it both ways.
No, I know.
Mr.
I explained before that but I was gonna bring her, Your Honor. That's what that meant. But I said I don't want to make you mad again because I didn't know if minors were allowed in here. I mean, it explains that before that. I mean, she wants to, she's 13. She wanted to make a statement to you about it because it's kind of her house. But that's what I meant by it. I take her everywhere since she was born. I have no qualms bringing her, but I meant that because I tried to find rides. We couldn't find a ride with the neighbors. They were all at work. John's the only one that can give me one. Car still broke down in the driveway, Your Honor.
Your Honor,
I'm
may I
not trying-
respond?
Go.
Please.
Keep going, Mr. Kelly, whatever you want to say. I mean,
I can tell you where it's going, and I'm not an
you
expert.
can't tell anything about it.
Okay, maybe you're right. I'm sorry. But this is very tough to just present it in a professional way and say it as I mean, but that's honest. I mean, I was trying to get a ride here, but that was the final decision. So I don't get a babysitter for her and go hitchhike down Michigan. I just said, since she's here, that was just meant that I made that decision after I couldn't find a ride. But I haven't skipped your court dates. I'm looking to save my house. I mean, and it's not necessarily,
Mr. Kelly,
it's not necessarily to stay there, Your Honor.
Mr. Kelly, I'm gonna stop you because
Okay. May I say,
you just sat here, tried to tell me some story about that you were going to appear. I'm going right to what you filed with this court.
okay,
I have good cause for my failure to appear. I did not appear / answer because, I did not go to the court because I had an emergency hearing regarding my 13-year-old daughter the night before. Says nothing about you actually bringing her. Says nothing about her coming to the court as though you just represented to the court. You didn't come because of her. I'm done.
I don't have it by memory. Your Honor.
I'm so done.
Please, Your Honor, I just wanted to.
Mr. Kelly.
You're gonna tow my house away with all my possessions? Not you.
Mr. Kelly, I'm gonna follow the law. I've listened to you all day and you keep going back and forth in some of these things. But I'm ready to rule. I've listened to the plaintiff, I've listened to you.
Please give me a trial, Your Honor. Please.
All right, Mr. Kelly, I gave a trial date for the parties to be here. It should be noted, although plaintiff didn't say much about it, plaintiff was here with all of their witnesses waiting for you to appear. Everybody interrupted their day. They were here ready to go and you didn't appear. And quite frankly, from the court's perspective, the court doesn't hear from you for a good 9-10 days after the trial date. Don't hear anything about what happened, this, that, nothing.
Sorry, Your Honor.
No, you don't have to be sorry. I'm just saying, you're distorting what has transpired. Plaintiff was here, ready to go, ready to, I'm presuming, state with specificity, have testimony and evidence regarding every one of their allegations. You do not appear. Your notion that you've been following the direction of the court, not true. I had to beg you to get an answer into me. I finally got that to happen, told you to pay escrow, you didn't do it, and then still didn't comply with the escrow issue. You may have your reasons, but don't say you followed the direction of the court when you didn't, and you know you haven't.
I guess I
And
should,
then-
I tried my best.
You know
I'm
what,
sorry.
Mr. Kelly, I have listened to you all day.
Right.
Now is my turn. I do not want to be interrupted. So for the reasons, part of the reasons regarding your, as I've indicated, there are two prongs you have to satisfy. One is you had good cause for not appearing. You have by no means established that you had any good cause whatsoever from appearing on that date. Now, you make it sound regarding your arrest on the bench warrant as though somehow or another you were manhandled, put in jail, locked in a cell, way down. Let's be real about what happened. You got locked up because there was a valid bench warrant out of 14A4 District Court. My court, but handled by another judge. That judge, as I told you, happened to be here that day. We took you into custody. I spoke with her to make a determination as to what to do. And one thing you never said about it, ever, because you're just trying to create sympathy, is you were released that same day. Told what your trial date was, told everything, and you were released without having to post. In fact, when you came back, I arraigned you on the bench warrant and gave you the date to go appear for your driving while license suspended. So don't make it seem like somehow or another this evil judge all of a sudden locked you up on a driving while license suspended and just left you sitting in jail, and that because of that you could barely get yourself out of jail and then appear for trial. That's not what happened. Do not interrupt. And then you sit here with these meritorious defenses or whatever you're trying to claim are defenses. I agree with plaintiff. You have not established any of those defenses, particularly the one you keep trying to harp on, which is a retaliatory conviction. There's a predicate before you can even allege that. You've not even gotten there. Nothing you've alleged is even close. So you don't even have to go through a further analysis of it. You haven't started that type of action against the plaintiff. You've not stated it and haven't shown anything regarding that. The cold-hearted reality regarding the meritorious defenses is, and this is just the reality of how it works, plaintiff would have to just show one, and it could lead to your termination of your tenancy. When you place yourself in this position, you have to show me a meritorious defense to all of their claims. You failed to do that. I honestly don't believe that you've established even one, but you certainly have not met or established any defense whatsoever to any of these claims. I'm done. You just haven't established. And so for those reasons, your motion to set aside the default judgment is denied. The court specifically finding that good cause nor meritorious defense has been established. The judgment will stand, the writ of restitution will issue. Because the writ of restitution is issued and there hasn't been a written answer filed to the motion to remove the manufactured home and the time has passed, the court will also sign that order and grant that plaintiff's motion regarding that. I am.
All my
Thank you.
stuff's in there, Your Honor. All my daughter's stuff, the neighbor's stuff. And my equity in the home. I want to say thank you that day. I did say thank you. It's on the record for you letting me go home that day I was caught. I was very grateful for it, so.
Your Honor, I believe I submitted proposed orders for both, an order denying
Yes.
attendance and a motion, and an order granting our motion.
And I have signed that order. I have signed the writ, and I have signed your order regarding the removal of home.
Thank you, Your Honor.
Well, that's one trailer that's not going to be in that trailer park much longer. I don't know how any of that works, but yeah, Mr. Kelly is out. He is done. That deal is over, and I'm sure Miss Dornbush is really happy about that. And you know, Judge Simpson's happy about that, especially after a 10-hour-long docket. Now, he wasn't actually behind the bench for 10 hours, but, you know, he was there at the courthouse, 10 hours dealing with stuff like that. We're wrapping it up here, ladies and gentlemen. Saturday afternoon, go find something to do, get yourself some lunch, enjoy the rest of your day and the rest of your weekend. Keep an eye out for some more videos that might be coming out this weekend. Keep an eye out for the live streams. It will be happening all week long with the Fleischer Forum starting at 8 p.m. Central Time, 9 p.m. Eastern Time. I'm your Lone Wolf Usul. I'm your curator and host for these videos. I appreciate you all. Chat's been wonderful. We'll see you next time. Thank you for that, Otto. I really appreciate that. That's awesome. See y'all next time.